Good afternoon, good evening. My name is Lutz, and it is my pleasure to warmly welcome all of you on behalf of REDRESS, the SOAS Center for Human Rights Law, and Forrest Medico-Legal Services to the UK launch of the Istanbul Protocol 2022. Today is an occasion to celebrate the Istanbul Protocol, or in short IP, to familiarize ourselves with the main changes made in the new edition, and to reflect critically on its use in the UK, particularly in the asylum and detention context. The IP is among the most impressive human rights documents produced by practitioners. It is recognized as the international standards to investigate and document torture and other cruel, inhuman, or degrading treatment or punishment. The IP had an enormous impact worldwide over the last 2 decades or so. In 2014, the then UN Special Rapporteur on Torture concluded that, and I quote, properly supported cases with good quality forensic reports are revolutionizing investigations of torture and improving outcomes, end of quote. The IP is testimony to the wonderful dedication, determination, and labor of everyone who has contributed to both editions. The 2022 edition was coordinated by 4 civil society organizations and 4 core UN human rights bodies. More than 180 participants from 51 countries worked on it. This makes for a truly international document that reflects the knowledge and experience of health professionals, lawyers, and human rights defenders from around the world. We are immensely privileged to have some of the key architects with us in the room, physically and virtually, and none less so than Dr. Vincent Iacopino. REDRESS, represented by Chris Esdaile today, was of course one of the 4 lead NGOs. And we have 3 out of 8 chapter editors here, Dr. Iacopino, Dr. Juliet, Cohen, and myself. Turning to the role of the IP in the UK, organizations such as Freedom from Torture have produced medico-legal reports that have been used in international human rights cases, such as in that of the late Osman Humeida against Sudan. That said, the main role of the IP in the UK is arguably in the field of asylum and immigration law, from status determination to immigration detention. In our later panel discussion, we will consider further the potential of using the 2022 edition in the UK asylum system and how to address some of the challenges experienced to date. It should be noted at this stage already that these challenges are not merely of a technical nature. We are confronted with a political reality that continues to be immensely hostile, not only to asylum seekers and other migrants, but also to the very rule of law and human rights. And obviously the Istanbul Protocol forms part of this broader struggle. Let me briefly remind everyone of the running order tonight. First, Dr. Iacopino will be providing a brief overview of the IP 2022 at the global level before Dr. Cohen will discuss key medical changes therein. Chris Esdaile will focus on the IP's role in securing reparation and justice, and he will be joined by video link by Olivier, a torture survivor and REDRESS client, who will be talking about the role of the IP in his case. This will be followed by a panel discussion on the role of the IP in the asylum law and detention context, and we are delighted and privileged to have with us for that discussion Stephanie Harrison-Casey, Rachel Bingham, and David Rees-Jones. and I will moderate that session. We will then have a good half an hour for question and answer session, followed by a reception at 7 p.m., which is courtesy of Freshfields, our host tonight. Right, it is now time for our first speaker, who will join us virtually. Dr. Vincent Iacopino is a former senior medical advisor at Physicians for Human Rights and adjunct professor of medicine, University of Minnesota Medical School. He is one of few people, if not the only person, who truly knows the IP by heart. He was instrumental in getting it off the ground in the mid-90s and was the ultimate driving force behind the 2022 edition, superbly coordinating it throughout. He has a wealth of experience applying the IP in a range of settings. In other words, we could not be more privileged than having Vince here as our first speaker to introduce a new edition of the IP and to speak to its importance worldwide. Vince, the floor is yours.
Thank you, Lutz. It's so good to see you, and the privilege is mine. I'm really happy to be with everyone today, and I've been asked to speak about two things to get us started, and that is the origins of the Istanbul Protocol, how it got started, and a little bit about the global context to expand the understanding of what it means to people around the world, perhaps to complement the UK experience. And so in 1996, there was a human rights and medicine conference in the southeast of Turkey where the conflict was raging in Adana, Turkey. And during a lunch break, we had a meeting, and one of my US colleagues from another organization floated a research idea that I didn't particularly agree with and made a counter proposal that I thought would benefit our Turkish colleagues. You see, at that time, there was no framework or guidance for conducting clinical evaluations of torture and ill treatment, and their evaluations were submitted to court. They were routinely rejected, and instead, the state relied on sort of false testimony or inadequate testimony by state forensic doctors. And so the idea that I floated was to establish a framework, guidance that would allow our Turkish colleagues to submit their so-called alternative reports, which were fabulous, and also to compel states to abide by the same set of rules and guidance so that they could be held accountable for clinical evidence of torture and ill treatment. It was a seemingly innocent proposal at the time. None of us around the table, there were about 8 of us, really understood the implications of what we were proposing. But everyone agreed around the table. And there were some, interestingly, there were some forces behind this. I was aware of the need for such a framework. And I wanted to support our Turkish colleagues who were being arrested left and right for their attempts to document and to provide treatment to survivors. But also I was aware of the Minnesota Protocol, which preceded the Istanbul Protocol. These are the UN guidelines for effective death investigations. And I had been working in Turkey for the past year documenting torture. Physicians for Human Rights, the organization I worked with, we published this book, and the first appendix in this book on torture in Turkey is actually the evaluations that I conducted, the guidelines I used to conduct my evaluations, and that really was the first draft of the Istanbul Protocol. And in addition, I was teaching health and human rights. I was just getting started at Berkeley in the US and learning about women's human rights. I had attended the 1993 World Conference on Human Rights in Vienna, and I witnessed the way in which women's human rights were evolving. And it was the idea of empowerment, of writing our own guidance to empower ourselves. And so all of those forces sort of came together rather innocently. And fortunately, we had a very strong UK contribution. not the least of which was Nigel Rodley, who was the new special rapporteur, UN special rapporteur on torture at that time. Not to mention people from what was the Medical Foundation at that time, Michael Peel, Duncan Forrest, and others. Vivian Nathanson was working with us. And yeah, over 3 years, we managed to get a consensus from about people, countries, and Jill referred to the Istanbul Protocol in his reports to the UN. There were resolutions that followed, General Assembly resolutions and so forth. And I think the uptake of the Istanbul Protocol guidance really was based on the need and the practical use in the field. It was it was driven primarily by civil society and our needs at the time. As you know from the current edition, you know, the origins of the Istanbul Protocol are still continuing, and you know the contributions that Lutz and Juliet and so many people have made have really strengthened the Istanbul Protocol. So I'm going to just talk a little bit beyond the asylum adjudication process. I know you're all familiar with that in the UK, and that's the usual way in which the Istanbul Protocol is used. But realize that there are many other contexts, medical legal contexts, criminal defense, prosecution cases. You know, in some countries where torture is widespread and systematic, the IP has helped to foster first ever evaluations of torture. In Turkey, for example, the case of Baki Erdogan, where for the first time ever, five perpetrators were convicted for a term of about 5 years of torture. And in Central Asia, where I've worked, so it really has been a fulcrum to turn around, you know, the effective prosecution and punishment of torture and ill treatment in a number of countries. In the U.S., where I am, we've helped to expose the U.S. torture regime from 2004 onward by examining former Guantanamo and detainees from other countries, reviewing medical records, testifying in habeas corpus cases. One that you may be familiar with is Mohamedou Salahi, whose case I testified in, his habeas case. There was a movie recently about his plight and torture called The Mauritanian. He wrote a New York Times bestseller called Guantanamo Diaries. And it's the Istanbul Protocol in its authoritative guidance that makes the judicial system stand up and notice. I mean, clinical evidence of torture is perhaps the most powerful form of evidence of the allegations of torture that people make, right? It's done in secret, in clandestine settings, and it's very hard to get evidence, but the physical and psychological evidence that we can detect is often critical in those judicial decisions. In human rights investigations, the Istanbul Protocol has been very important in documenting war crimes, crimes against humanity, you know, and working for Physicians for Human Rights. We've used the Istanbul Protocol in dozens of different countries over the years, from Kosovo and Chechnya, Afghanistan, Sudan, Iraq, you name it. Currently in Ukraine, we just trained Ukrainian clinicians who are investigating torture, and also in Iran. We've just developed training materials for health professionals who are about to document torture of the detainees around the protests, the recent protests. So human rights investigations, monitoring and prevention visits. As you know, the UN subcommittee on the prevention of torture and their national counterparts, so-called national preventive mechanisms, use the Istanbul Protocol. The clinicians who go there, and they're able to gather clinical evidence of torture to make the case and to aid in that exercise of prevention. Also, the UN anti-torture bodies like the UN Committee Against Torture the SPT that I just mentioned, the Special Rapporteur, they refer to the Istanbul Protocol. They make recommendations to states that they need to apply the Istanbul Protocol systematically in their countries. And as a result, oftentimes trainings happen and implementation efforts that we've interacted with them for a good 20 years, and it's a very powerful complementary partnership, having the UN and civil society working hand in hand. Capacity building ever since we developed the norms for the Istanbul Protocol. We have been implementing the Istanbul Protocol amongst health professionals, legal experts, judges, and so forth. And we eventually learned that it wasn't enough to have guidance just on legal and clinical evaluations of torture, but we actually needed to provide the conditions for torture. So we have developed guidance in the 22 edition of the Istanbul Protocol on what those conditions are. The political will, the criminalization of torture, and ratification of instruments, et cetera, procedural safeguards for detainees, how clinical investigations and legal investigations should take place, et cetera, et cetera. And so IP implementation, as we call it, is really quite important and a new element in the Istanbul Protocol. And lastly, I'll say that we've developed a coalition such that when our friends and colleagues are under threat, as Dr. Şebnem Fincancı is in Turkey right now, we all get together and we are taking actions to support Şebnem and others who face risks for documenting torture. And the Istanbul Protocol, is the process, the procedure, has really informed a number of other similar initiatives to establish guidance on human rights documentation. For example, the new Mendes principles on interviews, the sexual violence, the protocol on sexual violence and conflict that the UK spearheaded, the Berkeley Protocol on digital open source investigations, and most recently I've had conversations with people who are working on the Murad Code. I'll say that, in the new edition of the IP, that the definition of torture has expanded to include non-custodial settings. So oftentimes we are applying IP standards to things like, in the United States, forced separation on the US-Mexico border, or the excessive use of force in crowd control settings, use of tear gas and projectiles and so forth. So I believe I'm out of time. I will leave it at that, and I'll leave it to you guys to discuss how and why we strengthened the Istanbul Protocol. Again, the UK experience was really quite important in many of those changes, and I know that Juliet and others will speak to that. Thanks so much.
Thank you so much, Vince, for this brilliant whirlwind tour about how you've used the Istanbul Protocol, how others have done so, and really reminding us that it's at the heart of the international anti-torture movement. It's really a network of people using these documents to speak out against torture and to seek justice and accountability wherever possible. Now it's my great pleasure to introduce our next speaker, Dr. Juliet Cohen. She's a former head of doctors, freedom from torture, and now an independent forensic physician. She's also one of the editors of the Istanbul Protocol, namely the chapter on physical evidence, drawing on her very rich experience. I had read that Juliet had written over 1,000 medico-legal reports on torture, but she corrected me before the event when we spoke to say that she's now reached the 1,500 reports mark and probably still counting. So in recognition, surely of your ongoing contribution to the medico-legal documentation of torture in the UK and elsewhere. I think we are delighted to have you and to guide us through what has been updated in the Istanbul Protocol 2022 and what the latest reflections are on the physical evidence of torture. Juliet, the floor is yours, please.
Thanks very much, Lutz, and it's a pleasure to be here tonight. So I'm going to talk about the changes, particularly about the physical side of things and other clinical aspects of the new edition of the IP. As Vince said, it was tremendously important to us all when we began this new edition to preserve the status that had been established over the last 20 years for the IP. And the quote here from Juan Mendez, former UN Special Rapporteur, is that the standards in the IP serve for evaluation of medical evidence, a reference tool, and a benchmark for assessing the effectiveness of domestic fact-finding and redress for victims. It's crucially important, and it has that international global recognition. And here in the UK, as we've said, for asylum and immigration field, we have achieved great things. We've got it recognised by the Home Office in their asylum policy instructions, in case owner training, in detention standing orders for Rule 35, and in the immigration tribunals. So part of that process of preserving the status was that the Istanbul Protocol principles, which are set out in Annex 1, and the Annex 4 template for the overall content guide to the reports has not changed at all. There's literally no change in those parts. So those Istanbul Protocol principles are here just summarized, essentially the very core of an MLR. What is essential to include? The biodata, the consent, a record of the events, dates, and alleged methods of torture, the symptoms, the findings, and crucially above all, the interpretation as to the probable relationship of those findings to possible torture or ill treatment. And then, in addition, a recommendation for necessary treatment or further examination and the authorship. And those are really the things you can't leave out if it's going to be an IP report. But I'd like to draw your attention also to paragraph 268 in the new edition, which states that the purpose is to provide a clinical interpretation of the degree to which clinical findings correlate with the alleged victim's contention of abuse and a clinical opinion on the veracity of such claims and the possibility of torture based on all the evidence and findings, interpretations and conclusions. So the duty of the report writer is really to do these two steps, to interpret the findings, but also always to give an opinion about the veracity of those claims. And we'll talk a little bit more about what we previously discussed as consideration of fabrication in a moment. So what's in the new edition? I have a hard copy, which is very nice to have, but you can easily download it online. One of the big changes you'll see clinically is that we've rationalized Chapter 4, which was the general interview considerations, bringing in content that belonged there because it's common to any assessment, whether it's physical or psychological. So we brought in stuff from Chapter 5 and Chapter 6 because it's of general value to assist any clinical interviewer and indeed any legal interviewer, because there's important guidance for anyone who's interviewing a torture survivor to pay attention to. Chapter 4, you'll notice, has therefore grown quite a lot, both because of that and also because we expanded parts of it, particularly on memory and disclosure. And hopefully we've provided some better guidance now, clarifying it on interpretation and the use of the scale of consistency assessment. So in the UK, I think you'll know that we've habitually only really done these consistency levels for the physical findings and drawn back from any further use of them. And we've now clarified that as to how to actually do it better and how to, if you wish, use it for psychological findings and for an overall assessment. We've got fabulous updated body diagrams with much clearer drawings and a better range of them. We've updated the references and diagnostic criteria to bring them up to date. And there's some new content on examination assessment of children, LGBTI concerns, genital mutilation, virginity testing, forced anal examination, things that we weren't really on the radar of the clinicians 20 years ago, but which more and more are a concern. And then we've added 2 new chapters on the role of other clinicians in documenting torture and on the effective implementation, the state's duties about implementing the IP. And as Vince said, we were able now to cross-reference with these other UN documents, which are either new or updated since the last edition. I know a lot of doctors have said, where's it gone? Where's my favorite paragraph to cite? Because I want to be up to date. I don't want to use 187 anymore because that's old. So here you go. That wonderful list of inconsistencies, unchanged. 142 is now 342. When you're looking for a paragraph that you used to love in the old edition, if you look at the section that it falls within a chapter, it's very often still within that section, unless it's moved from chapter 5 or 6 into chapter 4. But the following chapter about the broad account stands up over time, even if there's a few changes, is still there. And that important one about the absence of evidence doesn't mean they haven't been tortured. It's still there at 393. Also, one I use quite a lot, that injuries may heal, and the history and the healing process is very important. So if they've got no scars now, that may be entirely as expected from what's happened. And as I said, the consistency levels that used to be just in one place in 187, we've now got them in all 3 chapters. So chapter 4, chapter 5, and chapter 6. And in order not to be unwieldy, what I'm doing really is using the chapter 4 reference 380 gives you the levels, not consistent, highly consistent, typical, diagnostic. You only really need to quote it once, but if you're only doing a psych report, perhaps you'll want to go to the chapter 6 reference. And that overall evaluation paragraph 188, so in chapter 4 that's repeated at 383, but it's also again repeated in chapters 5 and 6. Another key paragraph that we had at 236 was that no psychiatric diagnosis was necessary. Not every torture survivor has a recognized diagnosis, and that's preserved at 493. And those psychological formulation questions that we used to work through at 287 have moved to 540. But as I mentioned, there has been a change and a shift about how we consider fabrication, or what we think you should be doing when you're considering fabrication. So the statements at 105F and 2876 about a false allegation of torture doesn't have an exact transfer. That phrase is not copied over, but there's a number of different paragraphs that you can look for, and I've got another slide with those numbers on in a moment, which contain, I think, useful statements that you can cite to back up your opinion. Just before we get to that, the physical interpretation, as I said, has moved, and it's also in Annex 4. The Annex 4 template is something we haven't really used a lot in the UK. I remember being very surprised when I went to Netherlands and saw them producing this entire template verbatim and dutifully filling in every single section. And I thought, oh, we don't do that in England. Oh, dear. Maybe we should have been doing that all along. It's actually quite good stuff. There's some really valuable sections in there, particularly I find about correlating acute and chronic symptoms. When somebody's physical signs have healed, when they don't have any, the symptoms may be all you've got, but they may be very significant. And the information about known torture methods and their effects as used in a particular region, well, we don't always have reliable information about that, but if we do, we should use it. So, assessing the overall consistency of physical findings. Again, I think this is something that a lot of clinicians haven't really been doing much of in the UK, but I find it really helpful to sum up your findings and to give strength to your findings. So what might that look like? Well, if you've got one scar that's highly consistent, 2 that are consistent, and several where they couldn't really give you much attribution, but they could have been caused by the trauma described, the overall consistency has to take the highest one of those. So the physical findings overall have to be highly consistent with the torture or ill treatment described. They can't be lower because you've got one scar that is highly consistent, so you can't go down from that. Doesn't matter how many lower level ones you've got, the higher finding has to carry, trumps everything else. And the psychological interpretation, Again, we still consider the context, the fluctuations over time and in response to stressors and treatment. And some people do want to use consistency levels. So it turned out when I got this wonderful opportunity to find out what other people in different countries were doing as we worked on this new edition, is that some people were using these levels for psychological findings, even though we've never really done it in the UK. I think most clinicians haven't done it. So there was a range of opinion as to how possible clinically it was and how useful it was. But the good news, I'm sure you'll be relieved if you find this a little bit daunting, is that you don't have to do it. So when the consistency is used in the psychological findings, it refers to connections between whole sets of traumatic experiences and the overall presentation. No one is suggesting that you do a consistency level for anxiety, nightmares, every single symptom. That's not what's required. The primary question is whether everything that you found makes sense and the extent to which it's explained by the abuse alleged. So there is a use of the word typical, and it refers to expected or typical reactions to extreme stress. So again, it's a slightly different meaning than in the physical findings. And it's stressed in this chapter that a typical psychological reaction is not more meaningful or more corroborative than a highly consistent one. I know this sounds a little bit like, wait a minute, you're contradicting yourself. There was just a range of opinion and usage, and we had to try to be inclusive of all opinions for a global internationally used document. But you don't have to do it. Depending on jurisdiction, paragraph 543 says you can use these levels or not use them. It's your clinical decision to do that. If you did want to understand what I think is meant by a consistent level, I would say that refers to relatively non-specific anxiety or depression symptoms that don't really have a clear link to the torture that's been described, but could have been caused or exacerbated by them. And I might find that in a person who had perhaps a relatively low impact torture experience, perhaps it was a very long time ago, perhaps there's a lot of evidence that they were previously anxious or depressed, and it's just got a bit worse and maybe it's a bit better now. So it's a low-level finding. Whereas a highly consistent finding would be a much more specific relation to the torture in the content of re-experiencing symptoms, but perhaps there are other things going on. They may have grown up in a conflict zone, for example, or spent time in other places where they suffered harm. And again, typical diagnostic, some people would never use those terms, some people want to be able to use them, and you can decide for yourselves what works. As long as you show you're working, I don't think there'll be any problem. The key thing is to show you're working so that the decision makers can understand why you've come to the conclusion that you have. So somebody asked me, well, if you only say highly consistent, does that risk downgrading the reports by decision makers? Will they say, oh, but there's loads of other things that could account for this? I guess the answer is it depends. If there are physical findings that have a higher level of interpretation, you might find the combination raises your overall evaluation. If they're also highly consistent, you might consider that highly consistent physical and highly consistent psychological gives you a higher overall rating, and you might use some reasons, show you're working to justify that. But I think it's most important to remember that it should still reach the required standard of proof. Highly consistent is and should be enough. You can add details of context and specifics and triggers and avoidance behaviors that make other causes less likely or less primal to the presentation. Again, explain your reasoning. And remember, of course, not everyone has many or any scars, and not everyone has a diagnosis. So this shouldn't be the only thing that concerns you about interpreting and concluding your findings. So I said I'd come back to fabrication, where we used to make this explicit consideration. That's now been deleted. I kind of want to say there's only one reason why that happened, and Stephanie knows what I'm going to say because it's KV. Which was very influential, but I'm going to leave you to talk about that if you wish. So what we have now is that 268 paragraph I showed you at the beginning about considering the veracity of such claims and the possibility of torture. We've got that old paragraph that acknowledges the possibility of a false allegation or of exaggeration, but states that such fabrication requires detailed knowledge. So that's still there to be used. And we've got a new paragraph addressing self-infliction. And here you'll realize the echoes of KV, those of you who remember that case. Clinicians do not have a duty to consider these possibilities in the absence of any evidentiary foundation, since judicial decisions are based on the existence and weight of evidence and not on hypothetical possibilities in the absence of supporting evidence. I think Vince was quite cross when he wrote that. So 420 gives you more information on considering other possible causes, acknowledging the possibility of fabrication, but not making it so prominent. And 423, again, goes further. Signs of injuries in unusual locations, a diffuse spread of injuries all suggest torture, as does the finding of multiple modalities of blunt force, sharp force, and burn injury. That's just a summary, really, of Annex 4, the conclusions and recommendations, which, as I said, we haven't been habitually using in the UK. It's unchanged. It's where it has been for the last 20-odd years. I think it's quite useful. I think it's worth looking at that, particularly I find if you've got a slightly unusual case. I had a case recently of doing a telephone assessment, no picture, voice only, on an open line of someone who was in prison in another country. And so they advised me that there were things they would not be able to say because they knew people were listening. There were things, therefore, that I couldn't ask them about. I couldn't see what they looked like or how their expression or demeanor might change during the questions. And it was very challenging. But what there was a lot of history of acute and chronic symptoms and some psychological findings. And going through these sections in detail, I found extremely helpful. So sometimes we have odd reports and difficult cases, and coming back to the template can be really reassuring. If we state our opinion on the consistency between all sources of evidence and allegations of torture or ill treatment, are we stepping outside the boundaries by making a judgment on credibility? I don't think so, but I think you have to be quite clear about your wording in order to avoid that criticism, because it's a common one that is still levied at report writers. It's about your opinion on the consistency between the evidence and the allegation, and nothing more, and keep it confined to that. Now, we've got some good stuff here in a new paragraph, 265, which I think a lot of people will recognize some of that wording from the asylum policy instruction that UKVI have to use, reminding them of the correct standard of proof, not making clinical judgments that they're not qualified to do, not dismissing clinical evidence on the basis of a prior negative credibility finding, and the lack of evidence does not establish the person has not been tortured. All of that, I think, is really helpful to have it in the IP as in the international document, which carries more weight. So this new chapter 7, am I running out of time? Yeah, okay, we'll go super quick. States should provide training. All clinicians should be aware of their ethical obligation and obtain the training. Lack of training doesn't diminish their ethical obligation. And if they haven't got enough time, that's not acceptable. It's very, very clear. And there's a lot of guidance for these health professionals on all their other duties and clinical demands based on them. So what have we got? We've got comprehensive guidance. Please avoid the term compliance. I don't think it's helpful. We're using guidance, because if you use compliance, then people will try to undermine the report and say where it's not compliant. And one of the reasons that I think it's particularly important right now is the Home Office has introduced a new attack on our competencies in asking for second opinions on medical reports by external doctors on those in detention. And they're going to have those reports reviewed by 2 unknown doctors. We don't know what their training is. We don't know if they even know about the Istanbul Protocol. And their opinion is going to be given significant weight, if not allowed to overrule the opinion of the IP-trained doctor. So just as in the origins of the IP 20 years ago in Turkey, we have the state seeking to overrule and undermine clinicians who are experts. And I think we have to be very, very careful about what's happening there. It's a great document. There's huge flexibility of approach, and I think it's going to serve us very, very well indeed. Thank you.
Thank you, Juliet, so much for this brilliant presentation, and apologies because I know you mentioned time to do a proper evaluations, and obviously had we had more time we would have liked to hear so much more given your rich experience. But given our packed schedule, we have to move on to our next session, and we're welcoming for this session Chris Esdaile, who's solicitor and legal advisor at REDRESS, which works with survivors of torture to obtain reparations. Prior to joining REDRESS, Chris worked at Eddaile on corporate accountability litigation and on claims resulting from ill treatment by British forces during the Iraq conflict. So he brings a lot of international experience with him. He also worked in both South Africa and Chile, and he was, of course, also part of the editorial committee for the IP. And Chris will be joined in this joint session by Olivier Acuña. So that's REDRESS, so we don't have a separate slide for him. He's a client of REDRESS and a survivor of torture in Mexico. By profession, Olivier is a journalist, and he has lived in the UK for a number of years since fleeing Mexico, and he will be joining us remotely. Over to you, Chris, to enlighten us on some of the legal issues pertaining to accountability and justice. Chris, the floor is yours.
Thanks very much, Lutz. So, a little bit about law then, a little bit about law and the Istanbul Protocol. Now, I know that many of you will be approaching this from the point of view of the asylum and immigration system, but we didn't want to pass up this opportunity to flag up some of the other really important and powerful uses of the Istanbul Protocol. And I should at this stage say that there is a fantastic chapter, chapter 1, in the new edition, which is much expanded from the old version, and which will give you a pretty good overview of the law on torture and some of the developments that there have been over the past 20 years. But I'm going to talk a little bit about accountability particularly. And Juliet's already helpfully used this quote from Juan Mendes, but I'm just going to focus on the very last part when he stresses that, that the Istanbul Protocol can be a means of redress for victims. So what do we mean by redress in that sense? So it might be worth considering a couple of concepts here. Redress being a goal for transformation. That means that we're looking at changes in social and economic, political structures and relationships which can deal effectively with the factors that allow torture and ill treatment to take place. And importantly, that we're responding to survivors' needs, and we're attempting to restore dignity and humanity to those who've been so damaged. And then the second concept is reparation. And the goal of reparation is healing, making whole what has been broken and wounded, restoring dignity, humanity, and trust, helping survivors to come to terms with what's happened and the consequences of trauma and their injuries, and helping to break the cycle of violence at different levels. That might be at an individual level or family, collective, institutional, or perhaps even at the level of society. And if we think about what reparation means in terms of the international human rights system, then the international human rights system usually looks at 5 elements. And restitution is all about reinstating the victim to the situation they were in before this horrific violation was committed, usually accompanied by measures to try and address the structural causes behind the violation. So that might include things like restoring someone's liberty or reputation, giving them their job back, or restoring property to them that's been taken. Compensation, lawyers in the room will be fairly familiar with this, and this is one of the tools that is most common perhaps. Obviously monetary in nature, but it might be dealing with both financial and non-financial losses. But the important thing here is that this is not sufficient by itself in terms of international human rights law to provide relief to victims of torture, and it needs to be coupled with other forms of reparation. The third one, which the clinicians in the room will be more familiar with, rehabilitation. And we're talking there about something that is holistic and includes psychological and medical care, as well as legal and social services. And we're trying here to be looking at ways in which the victim can be enabled to reintegrate into society and have their dignity restored. Satisfaction is a bit of a weird term, but we're really talking there about stopping the violation, disclosing the truth perhaps, taking sanctions against people who've been perpetrators. The release of public apologies might fall under this as well, building memorials, other collective and commemorative measures that acknowledge the violations. And then finally, guarantees of non-repetition. So measures that will prevent these things from happening again. And it could mean legislative reform, perhaps, changing policies, changing practices, ratifying treaties, for example, the UN Convention Against Torture into domestic law. It may involve training, police, detention staff, the army, judicial authorities, medical staff, other actors, training them to anti-torture standards. And it might also touch on the transformation of social norms to end impunity. So when we at Redress are talking about strategic litigation for reparations for survivors of torture, these are the kinds of elements of reparation that we're looking for. So what then is the role of the Istanbul Protocol in those kinds of processes? It's really how to conduct an effective investigation and to document torture in such a way that those who are responsible can be brought to account, that victims can receive redress, and that future acts of torture can be prevented. So Juliet's already set out a little bit about the role of clinicians in these processes. So this is a bit more thinking about the role of lawyers and why the Istanbul Protocol is important for them. I mean, it's worth noting that the Istanbul Protocol is not legally binding, as you probably know, but it does, as Vincent has already outlined, reflect the international standards that are in place. So treaties or customary international law. And we as lawyers need to understand the impacts of torture that are recognized in the Istanbul Protocol, the impacts of torture on survivors in order to represent them effectively. And understanding many elements of the Istanbul Protocol will help our practice in that regard. So how can we as lawyers interview survivors of torture? It's good for us as lawyers to understand how medico-legal reports are put together and the kind of factors that Juliet's outlined, and to avoid re-traumatizing the victims. So why is the Istanbul Protocol helpful for legal accountability or reparations? Well, it becomes a guide and provides a guide and a standard on documenting torture. It provides a guide on collecting evidence that might prompt authorities to reopen or open an investigation. It provides a guide on the evidence of torture that would support those ongoing investigations or prosecutions. It guides us on what happens when investigations don't happen properly, and the shortcomings of those investigations, and what should happen when those investigations don't happen properly. And it provides a guide on collecting evidence to support reparation claims brought at the national or at the international level before judicial and administrative bodies. So as Lutz mentioned, I'm going to hand over shortly to Olivier Acuña, a client of ours, and first of all, before handing over to him, I'm just going to give a little bit of legal context to his case. So we represent him in a claim before the Inter-American Commission on Human Rights, which is the equivalent of the European Court of Human Rights in the Americas, regarding his torture in Mexico in 2006. And one of the key issues in his case before the Inter-American Commission is the misuse of the Istanbul Protocol. He went through 8 medico-legal reports. Many were prepared by doctors who were working in the same state institution which tortured him. And it's worth pointing out, just before I hand over to him, that the protocol, the Istanbul Protocol, tackles the issue where health professionals might have conflicting responsibilities due to the circumstances of their employment or conflicting ethical obligations, especially when clinicians are employed in state institutions. So it's worth emphasizing that the new revision of the Istanbul Protocol expects clinicians to owe their primary duty to the patient and to make an unbiased assessment of the patient's health interests and act accordingly. So I'm going to hand over to Olivier now, who can explain a little bit more about his case, his experience of the use or the misuse of the Istanbul Protocol. Over to you, Olivier.
Hello, everybody. Thank you for having me here. Firstly, I want to thank REDRESS. Their team of human rights experts have assisted me for over 7 years, as Chris has just said. Without their help, I can confidently say I would have given up my fight or have lost it by now, because nobody wanted to help me with my case since I was exonerated and freed from prison in 2010. As Chris has said, my intervention today is to share my experience with the Istanbul Protocol in a country like Mexico, where the government uses this examination to hide the fact that torture is still common practice, and how this significantly affects victims and survivors and their families. Again, my name is Olivier Acuña. I've been a journalist since 1984. I began my career in Mexico, and at this point, I believe it is urgent to note that Mexico is today, and has been for several years, the most dangerous country to be a journalist. This year alone, 14 colleagues have been killed, and at least 10 of them for reasons linked to their work as journalists. Human Rights Watch recently reported that cases of human rights violations continues under the current administration led by President Andrés López Obrador, and that most of them remain unpunished. NGO Causa Común reported that over 1,150 cases of torture in 2021 took place, were reported then, but the fact is that many more cases remain unreported due to fear of retaliation. Even the government's census office has recognized that 69% of people detained, which in 2021, we're talking about 12,000 people, were tortured psychologically or physically. In my case, I've been waiting for justice for over 17 years, despite having at least one 100% credible Istanbul Protocol examination in my favor. My case dates back to January 2006. However, persecution and harassment began much sooner than that. In May of 2005, I took my claim against the Mexican authorities to the Inter-American Human Rights Commission, as harassment against me and my family had become highly unacceptable. 7 months later, I was abducted near my home by 9 armed men in 3 unmarked vehicles. They violently drove me away without any explanation as to why I was being taken. Psychological torture in my case, this is my experience, which was much more devastating than the physical one. Toward the end of the 16 hours of torture I endured, the men participating were trying to get me to confess to a murder I had not committed, but because I truly believed they were gonna kill me, which is common practice in Sinaloa when you're abducted in the way that I was abducted, I did not confess. Instead, I was begging them to kill me. And this they used against me as well, the fact that I did not confess. I am here against the odds, but after being tortured, another significantly distressing struggle for justice began. And this has to do with the Istanbul Protocol. A government forensic expert did the first examination to determine if I had been tortured, but all he did was open my mouth and within a minute concluded I had not been tortured. This, of course, because the police that had tortured me were present. The government would later use this examination to try and undermine the results of other examinations done by independent experts that with more in-depth examinations determined I had in fact been tortured. The second examination was carried out by a local psychologist working for a human rights organization. He interviewed me for a couple of days, concluded that there was no doubt I had been tortured. But again, his results were rejected as biased. So at this point, we began to see how important it is for an international, or we began to understand how important it is for an international Istanbul Protocol framework to be in place so that those who suffer torture can immediately be confirmed, verified, and receive the attention and justice they deserve. My fight continued. I underwent yet another independent examination by a team of 3 or 4 people, including a lawyer, psychologist, psychiatrist, and an assistant. Their probe took 3 very long days during which I was re-victimized. And yeah, it's important for everybody to understand that every time you are examined, you are re-traumatized because you go into detail into the instance of torture. And so this turns out to be sometimes as terrible as torture itself, to be honest. And this is another reason why it's important to have a real Istanbul protocol in place, so not several examinations have to take place. Worse yet, there were 3 or 4 more times where the government forced me to undergo an intensive examination under the promise that if I proved I was tortured, my case would be resolved favorably. Of course, they lied to me, and their intention was all the contrary. They used the ill-practiced Istanbul Protocol to discredit me, degrade me, insult me, harass me during and after the examination. And of course, the psychological damage was even worse because the examination was being practiced by the same authorities culpable of abduction, torture, and false imprisonment. And also worse because my family race, felt that finally there was going to be justice, and there was not. So they had to deal with the how psychologically I was affected after all these examinations, all the depression, anxiety, anger, and resentment affected everybody around me, not just family members, but even friends. And so the problem I see is that in the state, that the Mexican state has no will to punish torture or even admit that it is an issue. And when there is a case like mine, they do all that is in their power to discredit the person claiming torture. They manipulate the Istanbul Protocol to degrade the torture victim even further, to insult them, as I previously said, and more importantly, to discredit them and call them liars and therefore criminals, making them feel they deserve being tortured. And this is kind of like to force them to desist and give up their case. Finally, in 2018, thanks to REDRESS, I was re-examined again. And although painful, it was on this occasion, the Istanbul Protocol was practiced by globally renowned Istanbul Protocol expert, Dr. Pau Perez. And although he concluded I was tortured and that all 7 other examinations were plagued with errors, the Mexican government still today rejects I was tortured. Dr. Perez found that all of the medical reports prepared by the Mexican state institutions lacked the independence to comply with the requirements of the Istanbul Protocol. And this is despite the fact that Mexico alleges it agrees with the use of the Istanbul Protocol. Dr. Pau Perez's report also concluded that there is a massive evidence of significant deficiencies in the elaboration of all independent and government medical and psychological reports. A May 2022 report co-authored by Dr. Perez reveals that far from being a tool for obtaining justice, the government abuses the Istanbul Protocol as a method to cover up cases of cruel treatment and torture. This was 100% true in my case. I hope that from my case, you can all appreciate how crucial it is to fight in international forums in favor of a global Istanbul Protocol standard that is accepted widely for the sake of victims or survivors of torture and their families, and so they don't have to wait years to attain justice. We need to end impunity, as there is nothing more degrading than being treated like an animal and then being told publicly by judges, lawyers, and others that you are a liar when you're claiming you were tortured and even proving that it is the case. Thank you very much.
Thank you so much, Olivier, for sharing that with us. And with that, I'll hand back to Lutz.
Thank you, Chris, and thank you, Olivier, in particular, for sharing your experiences with us. Really also setting the scene, I think, for the panel discussion to come, also highlighting, obviously, how much is at stake when we talk about IP examinations and their use in any proceedings. Obviously, for torture survivors themselves, but also for everyone involved, be it to secure accountability in a country such as Mexico, or be it in the asylum and detention law context in the UK, to which we will now turn. Can I please ask all the panelists to come up and choose your seat? And then I'll briefly introduce you before joining you. So I'll start with you, Rachel, as you're the closest. Rachel Bingham is a clinical advisor at Medical Justice, and they provide training and support to clinicians visiting people detained in immigration removal centers in the UK, and write medico-legal reports using the Istanbul Protocol to document torture and the impact of immigration detention on health. So Medical Justice is very much an organization that is working at the sharp end of the UK asylum and immigration detention system. Next to her, David Rees-Jones. He's a senior legal officer at the Helen Bamber Foundation and co-founder and co-director of Forrest Medico-Legal Services. And the name is in tribute to the late Dr. Duncan Forrest, who was the inspiration for much of the early work on the Istanbul Protocol. Again, David brings a wealth of experiences with him. And last but not least, we have Stephanie Harrison, Casey, I still have to get used to that, yes, not QC any longer, from Garden Court Chambers, a barrister specializing in international human rights law and claims for international protection, and she has represented many survivors of torture, other serious ill treatment and trauma and organizations seeking to document ill treatment, including by the UK authorities. So very much a lawyer who is dealing with these cases hands-on and will have many insights to share in our panel discussion. Let me join you now here. And we have a first round of questions to warm up, so to speak, to learn a bit more about your experiences in using the Istanbul Protocol in your work. What would you say have been some of the most memorable cases, successes, and challenges as you see them? And we'll reverse the order now, so I'll ask Stephanie first, please.
Thank you. Well, I think it's been foreshadowed that certainly in the context of asylum determination, the role of the Istanbul Protocol has proved to be essential and critical tool for establishing claims for international protection based on a past history of torture or other ill treatment. It's recognised in the law that if you have been subject to previous ill treatment or torture, then that's at least a presumption that if you're going to be returned to the country of origin, that experience there's a real possibility that that experience will be repeated. So it's critical key material to establish a current claim for protection that you have suffered ill treatment in the past. Given the recognised difficulties that those seeking asylum have in being able to establish and provide evidence of past ill treatment, medical evidence is the most important, in many cases, evidence that's going to be realistically available to that person. And what has been central in the context of the Istanbul Protocol is where that methodology has been applied, the courts have recognised a number of important consequences of a medical opinion documenting injuries or sequelae, whether physical or psychological, with the account of torture, that material is therefore capable of corroborating the account of torture. So where there is a correlation between the account and the documentation of injuries or other psychological harm by the doctor, that is proof capable of proving to the standard required that the torture or ill treatment occurred. So in this context, that's the vital role that the Istanbul Protocol has had. It's also had the fact that it's also added to the fact that once you have a finding of a history of ill treatment or trauma, that's a critically important piece of evidence by which to judge the veracity of the account that's given, also to explain if there are inconsistencies or difficulties in the narrative that the person has given. That evidence is also going to be important in putting in context the account that the person has been able to give, often over many years in many different contexts. So for those two reasons, it's vital material in asylum determination, and it has been the key instrument by which we have been able to counter what is often called the culture of disbelief within the asylum context, and a pattern of rejection of accounts that are given by asylum seekers. Medical evidence has been the central way in which that institutional culture, which has become increasingly hostile to the recognition of asylum refugees and others in need of international protection, that has been the primary protection and safeguard that has operated in the system so far. And so it is really central to the asylum lawyers' tools for effective representation of their clients. So that's in the context of asylum determination. It's also been critically important in the context of identifying those who are unsuitable for detention and at risk of serious harm in detention, although one of the features about the standards in the Istanbul Protocol is that there has been a tendency in that particular context where it's not necessary to have evidence that is capable of corroborating an account. It has been used as a mechanism for increasing the levels of evidence that are required. So to that extent, I think that it has had an indirectly adverse, in some respects, impact when you have a regime that is only supposed to identify concerns of torture sufficient to therefore mean that the person is unsuitable, then to have ever-increasing requirements for levels of evidence at which the Istanbul Protocol is at the pinnacle as the gold standard has really created obstacles to release when you step back from it. So I think that's the one difficulty. And I think the final thing that I would say about the Istanbul Protocol is that it is a standard that, although those who work in the field, whether they're lawyers or medical practitioners, seek to achieve, it is categorically clear that the UK authorities do not apply it when it comes to the medical practitioners or the decision makers. And so its standards are observed in, are identified by the failure to apply it as far as the UK authorities are concerned, in particular in the asylum context. And that's both in determination, in detention, and also where there are allegations of ill treatment within the UK detention facilities. What's marked is the failure of the UK authorities to actually apply the Istanbul Protocol. So that has been an important part of what I've sought to identify through cases of ill treatment within the UK system.
Yeah, thanks so much, Stephanie. And obviously, I think it's very important to, as you said, also to see it in terms of the obligations that states actually have. We saw it from what Olivier told us about the situation in Mexico. I think it's too often seen as an instrument that is used by lawyers, and then counter strategies have been developed here by the Home Office and others. And obviously, it's not meant to be an adversary instrument, but it meant to reflect the best standards, or even to say minimum standards of documenting in the field. So I think that's a very important point you highlighted. David, from your experience, would you want to add anything to that quite comprehensive introductory account that Stephanie gave us?
Yes, I think, and following on from what you just said, Lutz, and what brought home to me is particularly by Olivier's discussion of the misuse of the Istanbul Protocol. So I guess I'd start by saying, be careful what you wish for. I remember sitting quietly in my office at Medical Foundation when I had the privilege to work with Juliet, and I was took a telephone call from a colleague of Stephanie's at Garden Court, Sonali Nayak, who said, I'm going back into court tomorrow. We certainly have the Court of Appeal on our side. Is there anything that you think perhaps we could add by way of submissions to improve the status of medical evidence? I said, oh, well, will you please ask the judges to talk about the Istanbul Protocol? And they did. They only quoted one paragraph, 187. And suddenly it all became about the scars. And then we had the introduction of scarring reports, which found their way into, of all places, the Legal Aid Agency, who will now pay for scarring reports, as if the scars are the be-all and end-all of torture. So I'm so pleased that Juliet has made and reinforced through her work and of course her colleagues in the new Istanbul Protocol, that we are moving away from scarring reports. We are no longer talking about counting lesions. We are now discussing clinical findings, which takes us back to core principles, I think. I just want to add a point on the issue of compliance. And I don't disagree with Juliet. However, I think that one can talk about complying with the guidance set out in the Istanbul Protocol without getting into the situation that Olivier warned us about, which is the Istanbul Protocol and the issue of whether or not it is fully complied with in its entirety, then being taken against the report and throwing that baby out with the bathwater. I think that we do have to find new frameworks, new terminologies. Juliet raised the case of KV, and we still bear the, dare I say, scars from that case. And learning has taken place and that the Istanbul Protocol now reflects that. It will be interesting to see whether the judiciary, whether the Home Office decision makers actually take this on board. And I think that one of the important aspects of the Istanbul Protocol that we mustn't forget, and of all medico-legal report writers, is that of educating the reader. And so, as Juliet said, you must show your workings. You must explain why it is that you're reaching your conclusions, and do so in such a way that the lay reader, even the judicial reader of the report, understands what it is, what point is being made by the clinician in demonstrating their findings and establishing that degree of consistency.
Thank you so much, David. I think we had two legal perspectives, obviously in your case with a lot of medical knowledge to go with. Now over to you, Rachel, from your experience.
Thank you so much. So, well, I'm really glad to have the chance to say in this forum what a fantastically useful and supportive document we find it. In my medical role, we have a group of doctors who visit people who are detained, as you said, in immigration detention. And we use the guidance of the Istanbul Protocol really at every level, from setting the scene for our assessment, so emphasising confidentiality, trying to establish trust, and even the setup of the room we're going to use. We've quoted the Istanbul Protocol to ask for appropriate facilities, appropriate private setting in immigration detention centres. And then we do use, as they've pointed out, the guidance to document scarring and physical and psychological consequences.
Yeah. Can I ask how responsive the authorities are to those requests?
In a sense, the Istanbul Protocol helps us to be authoritative. So, for example, some of our generalists could be criticised for, we might have very experienced general practitioner who's seen many refugees and survivors of torture, but could nevertheless be criticised for not being a specialist. They will be supported by being able to quote and refer to paragraphs in the Istanbul Protocol to show that their clinical opinion is supported by a body of expert opinion. On the other hand, of course, I really share the concerns Stephanie brought up about that rising bar for medical evidence and how that might also go against us.
Right. Thank you so much. Now, I want to talk about some of the key changes in the latest edition. And one new focus is on the role of a gender and child-oriented approach. And obviously, I think Juliet already mentioned that there were obviously a number of dimensions that were missing in the original version. I think we've all learned a lot in the meantime. I mean, what would all of you say is the added value of having a more differentiated approach that has a much clearer focus on what I think we would call in the UK protected characteristics? Maybe I want to start with you, Rachel, and then go back in the round. Yeah.
Thank you. Yes, I think there's very useful guidance for clinicians delineating the limitations of the medical role, for example, in relation to issues around LGBTQI, but also about setting up the conditions for a respectful assessment that respects people's human rights and would document the experiences of groups with protected characteristics. In my team of doctors, we hadn't used so much the guidance relating to children, since happily fewer children were in immigration detention, but unfortunately we're now seeing numbers of children and minors creeping up in short-term holding facilities. So we're now unfortunately going to be welcoming that new guidance. And we've also used that guidance because, of course, people who find themselves claiming asylum in adulthood have often had experiences in childhood and adolescence that are very relevant to their situation now. So we've used it there as well.
Yeah, obviously, these can be, in practice, very fluid categories. I appreciate that, certainly when it comes to age assessment. So again, I think we are confronted with how categories can be used to channel, if you like, legal treatment accordingly. So obviously, I think we cannot expect the Istanbul Protocol to answer all these questions in terms of how the legal systems work in practice, but certainly I think to have more child-specific standards, as you highlighted, is a great advantage of the revised version. David, anything to add?
I think it'll be interesting to see where we go in terms of issues around sexuality. I know that reports that I've seen from very early days of medico-legal report writing to what came close to Istanbul Protocol standards, the issue of sexuality was described more in terms of the start point for the report rather than a given as to being, as you say, the protective characteristic of that individual, concentrating then what happened to that individual because of their sexuality, and trying to look at matters in terms of this is an individual no different from any other. And it is the impact of their ill treatment upon them that we are documenting. We are not documenting their sexuality as a medical issue or a psychological issue. And I think medicine has now caught up with society. It will be interesting to see whether law follows suit.
Yeah, but I think it's actually also been oversight in international human rights law, because I've been looking into discussions sort of on discriminatory torture, looking at the role of race, sexual orientation, disability, children. All of these have been overlooked for a long time. Obviously, gender-based violence has been very prominent, but when it comes to other forms of discrimination in the context of torture, that has been lacking. So I think the Istanbul Protocol also certainly highlights that, and Chapter 1 sets out the applicable standards, as Chris mentioned. Stephanie, further thoughts?
I think it is important that in this version there is more focus on sex and gender-based violence, and we had an experience in the United Kingdom where the UK Home Office sought to draw quite a clear distinction between those who were subject to state-inflicted torture and those who were subject to non-state torture. And obviously you've got the parameters of the Torture Convention itself, which were sought to be exploited by the Home Office to suggest that there was a different experience, and particularly so if you were detained, if your experience of torture was non-state because it hadn't taken place within the confines of a prison. And so I think that was rejected by the court in 2017 in a case that Medical Justice brought. But that in itself, I think the new parts of the protocol that deal with acquiescence, and I agree with Chris about the opening exposition of what constitutes torture and ill treatment is very important in itself. And then when it comes to having a proper focus on forms of sexual violence which may be more likely to occur outside of the state context, I think that's a very important deficit that has been addressed in the updated version and will be important going forward, obviously recognising that a woman or girl's experience of ill treatment is going to be different, the forms of ill treatment are different, the way that they manifest, the impact on the person, all of that needs to be properly integrated within this guidance, and I think that those are really important steps that have been taken that will be of great use.
All right, thank you so much. I realize that we've already reached our allocated time, even though it feels like we've just started. So I hope you can indulge us for another 10 minutes or so, and then we'll start the question and answer session, because we haven't really been able to deep dive into the situation in the asylum system and how actually the Istanbul Protocol can protect people in the system. I think all of you touched upon various aspects of it, highlighted some of the challenges, also the politicization of the Istanbul Protocol itself. So how would you say, from a strategic, practice-oriented view, how can the new edition be best used in that context? What are the strategies? How can also maybe lawyers and doctors work even better together? Rachel.
Thank you so much. It's such a big topic, and I suppose the overview is that the asylum system currently, from a medical perspective, is riddled with harmful practices from the moment somebody presents themselves as an asylum seeker. They're expected to disclose a full history of what's happened to them. For example, it's sad that over 20 years later, despite all of the clinical evidence and the Istanbul Protocol, that the expectation is still a full disclosure at the first opportunity. I think that there are so many points at which people are then let down, kept waiting for months or years so that they can't even begin to engage in settling and rehabilitation and the other factors that a survivor of torture ought to be entitled to. From my smaller perspective, working in immigration detention, it is very clear to us at Medical Justice that there are deficiencies in the clinical care and the recognition of survivors of torture in detention. For a start, there are many survivors of torture, sadly, in this country in detention, and they need to be recognised and advocated for by the clinicians in the detention centre. But unfortunately, what we observe is that knowledge of the Istanbul Protocol in that setting is really deficient. So people are not identified, and then if they are identified and if reports are made, brief reports documenting clinical evidence of torture, the doctor may nevertheless conclude that they don't have concerns about the person being in detention, which clearly in the majority of cases shows a lack of understanding of the needs of a survivor of torture. So my real hope for this edition, I think it's spelt out really clearly the obligations of clinicians to be familiar with the Istanbul Protocol, the obligations of states to provide training to clinicians in the Istanbul Protocol, and that would somehow filter through, although of course the first point from my perspective would be that people who have survived torture shouldn't be in detention in the first place, and so it will need to feed into the wider system to enable that to happen.
Yeah, thank you so much. I would have asked all of you as a concluding round, what would be your one key point? You've given us at least 3 already. I think all highly valuable. What I find really striking is that a system that claims to be cognizant of the plight of torture survivors and puts something into place that is meant to protect them from detention is so obviously failing. So I mean that's a systemic policy failure, which is quite striking. One has to say. David?
Well, I'll follow on from that point, and what I would hope that IP22 will give us is some teeth, so that we can have a sensible conversation with doctors who work in immigration removal centres about their obligations to, first and foremost, their patients, and that they recognise that they are working under a dual obligation, and that they may owe allegiances to the corporations which employed them and through them to the Home Office. However, the paramount obligation that they have is to their patient, and that is an ongoing obligation. So it's not enough to say, well, this person may be a victim of torture, but on the day I saw them, they appeared to be coping rather well with their detention, and then never meet that man or woman again. There has to be an ongoing doctor-patient relationship with that individual. On that day, they may have been coping. at what point were they taken into their detention centre? Are they still coping a week after, a month after? And taking the point that Chris made about reparation and rehabilitation, it is a given, and everybody in this room clearly understands, rehabilitation cannot take place in a detention setting. And if the state has an obligation to a torture survivor, it is to ensure their rehabilitation, and therefore, why are we continuing to detain torture survivors?
Yeah, and I think the General Comment 3 of the Committee Against Torture makes that very clear, that also applies to foreign torture survivors.
Yes.
So important point you raise there. Stephanie, your position on the panel has the advantage that you will now have the final word.
Okay. I think what I'd like to just put into people's minds is that last year, well, this year and last year, there was an inquiry into abuse, mistreatment and abuse in Brook House Immigration Removal Centre, which a number of people were involved in providing evidence. And for the first time, there has been accountability for individuals who've been responsible for the immigration detention facility and the failure that we've talked about to identify, document torture victims, either in the context of their asylum claims or in the context of them being released from detention. And this is another opportunity. The combination of the fact that we have this important elaboration of the principles in the context of when this inquiry reports, which will be at the beginning of the year, because it will demonstrate without any shadow of a doubt the systemic failure of the UK authorities to apply the Istanbul Protocol approach, not only to the documentation of the victims of torture, but to the investigation, accountability of individual officers and others within that particular facility who are guilty of at least subjecting individuals to inhuman and degrading treatment, possibly even torture. And so I think that there will be an opportunity to combine the two, and I think that that is important, that the UK authorities should not be allowed to use the Istanbul Protocol as a straitjacket and as a tool to undermine claims, which is their general approach. They need to be held to account for their failure to do so, and in part to identify that as an element of the culture of impunity that goes from top to bottom in the Home Office that led to the exposure of the abuse that took place in 2017, and which all of those who operate in any way in that system know that is likely to be continuing now. And there will be no other way of exposing it except by undercover reporting, because that's what has been the only way in which this serious abuse has been exposed over the decade since immigration detention has been used. And that in itself is indicative of the failure to apply these international standards.
Right. Fitting note to end on, call for justice and end to impunity in the system. Thank you all so much to our three great panelists.
Thank you.
So we're going to move on to the question and answer session. And that is to the three panelists, but also both of our speakers. I don't know whether you want to pull up a chair and come and join us here, or whether you would like to remain where you are. You're happy where you are. People know where to find you. So if you have a question, if you like, please say who you are and who the question is directed at. If you want it to be answered by one of the panelists or Chris or Juliet, otherwise we'll have it as an open question. Please.
Kit Byatt, I'm a medical legal report writer from Forrest and Director of Education there. I'm just wondering how much, well, first of all, I've been fascinated for a long time at how differently doctors and lawyers view evidence. and appreciate it and weigh it up and use it. And I'm just wondering whether this is directed to all members of the panel really and others, whether the revised Istanbul Protocol may help each of those two tribes to understand a little bit better how the other one approaches things and works.
Yeah, I don't know which one of the tribal representatives would like to answer first. So.
I don't know. I have a different experience because as a lawyer, the Istanbul Protocol gave you the tools for identifying when a medical opinion was going to constitute probative evidence of a history of torture. So for me, it has always been the mechanism by which those two things have come together. And certainly, ultimately, that's the way in which the courts have approached it. That if it's a correlation between the account and the clinically significant symptoms, that is probative evidence of the torture or ill treatment. So.
Any thoughts, Rachel, Juliet, or are you all agreed? So maybe.
In my role, I do spend quite a lot of time sitting between the lawyers and the doctors, trying to explain the one to the other. And there are different approaches. What I do say to my clinical colleagues is that you are answered a question does not necessarily mean that you must answer it. And remember that you are giving an opinion. And if you cannot give an opinion, then say so. Do not be absolutely tied down. To the lawyers, very occasionally, we have to say, you may not want to ask that question. That's something that lawyers understand, doctors not always.
It's a not unfamiliar situation. The only thing I think of to add to that, I suppose, when I reread or first read this edition, is just how useful that legal background is for medics. And I suppose I'm very blessed to work with a network of independent doctors who tend to be very aware of their kind of ethical obligations and very interested in the legal area. But I think in terms of distribution more widely, that understanding of the obligations of doctors and their legal obligations and their ethical obligations perhaps couldn't be emphasised enough. So I suppose I'd like those two aspects to be brought together in any future training.
Yeah.
Right.
It shows I've got no insight into how doctors perceive lawyers. So I hold my hand up to that. But I think it probably is, but which we all might need to recognise, is that the need for lawyers working in this field and medical practitioners carrying out reports and providing support, we need to be communicating much more because there is no doubt, and Juliet explained about the Home Office's intention to adopt an even more aggressive and absolutely hostile response to medical evidence that they don't like the outcome to. So I think we are at a juncture where communication and discussion about our roles and how best to ensure that the evidence is going to be able to be relied upon is really important at the moment, this particular moment.
I think that's a very important point, and also in terms of advocacy, and how you can use joint advocacy, because obviously we all know how legal systems work and what the constraints are there as well. So I think to have a distinctive sort of medical voice saying this is highly unethical, adding to some of the legal challenges being brought is certainly very powerful.
Yeah.
Right, please. We have two questions, so you first and then one behind you. We'll take both.
Thank you very much. Just picking up actually on the advocacy. Thank you. Hello, my name is Olivia. I'm a clinical psychologist, and I've written reports for Helen Bamber Foundation and other places. But I had a question about the advocacy point, and actually maybe so there's two parts to this. One is a clarification around what's different in IP 2022 from the previous one, because on the one hand, I sort of feel like as clinicians, our ethical alignment kind of squarely always has sat with the client in terms of represent, from the Hippocratic Oath through to, other professions have their articulations of that. So I guess clarification question about what's changed if it's made more explicit in this edition. And then a very self-interested question related to that, which is that as a clinician that works in a refugee psychology service, my clinical reports might be discounted on account of the kind of, being an advocate being seen as a dirty word in terms of the fact that I've got my clients' sort of interests at heart and not seen as independent enough from a medico-legal perspective. And I wondered if there was anything in the new edition that might challenge that perspective. That might be more of an implementation of medical evidence question rather than anything to do with the Istanbul Protocol itself. But I did wonder if there was anything different on that because of that kind of ethical issue around whose interests are we representing. Thank you.
Right, very good questions. Let's take one more right behind you.
Hi there. Hello. Don't know what. Okay, yeah. My name is Brian. So I work for a charity called Migrants Organize, and I run a project specifically to help migrants and asylum seekers who lack mental capacity to engage with the immigration process. So my question is actually around how the Istanbul Protocol approached the issue of mental capacity to consent to the medical examination. I find it quite interesting that it kind of adopts the best wishes and preference approach, which is much more in line with UNCRPD, I guess. But then it doesn't really follow the Mental Capacity Act in the UK. So I was just wondering whether that has caused any difficulties in practice, for example, for you guys, when assessing someone who might not have capacity to consent to the medical assessment, or whether you have any thoughts on that. Thank you.
All right, very good. So who would like to start? Juliet, yes? Right.
So the first part of the question about, as I understood it, about dual obligation and whether you can be seen as independent, is that right?
Yes, you made the point that it makes it perhaps more explicit.
Yes, there's an expanded section, I think, on ethics in chapter 2, and where we used to have that term dual role, we've changed that now to conflicting obligations, because your primary and only role is to do your duty for your patient, and if you have conflicting obligations because the employer is putting pressure on you to do this or say that, then that has to come second to the needs of your patient. And so that is, I think, much more clearly set out and explained. I think also in this new edition there are a number more references to the obligation to refer when you've identified healthcare needs of the person that's been assessed, then to refer or make recommendations for referral and further treatment, and that is part of your process of writing the report. It was always there, but I think it comes up more times, and there's a little bit more explanation of that. I looked for any reference to whether treating clinicians can't write this sort of report. I couldn't find it. I'm happy to be corrected if I've missed it, because I really focus mostly on the physical chapter. So I don't think that's at issue in this document. And the point is really that if you're expressing your objective opinion and you identify if you find something that's not consistent with what the person said, then obviously you have a duty to point that out. But there's nothing that rules out a report by a treating clinician. So provided you can demonstrate that you're being objective and you understand your duty to the court, that's all you need to do. And then quickly about the other question, mental capacity. That question, that paragraph that you're referring to, which I can't remember the number of, but I know where it is I think an international context, and I think in this country we're going to be much more closely following the UK Mental Capacity Act. So yes, it's important to consider mental capacity if a person doesn't have capacity, and many times we're asked when writing reports to consider that issue. What does the person have capacity for, or fitness or unfitness to undergo interview, giving evidence, and so forth. and you have to just take each of these and follow your clinical knowledge and the Medical Capacity Act.
All right, thank you, Juliet. I think she has exhaustively answered all the questions raised. So we have time for a final round of questions. So we have 2 questions over here, 3, and that's it. So we'll take all 3.
Thank you. I'm Mira Nasir. I'm a legal fellow at REDRESS, and my question is for Rachel in particular. In your experience, where a detention facility knows that you are a clinician that closely follows the IP, have you seen that there is reluctance to give you access to those facilities and access to patients? And then on the flip side of that, when dealing with clinicians that are employed by detention facilities, do you feel that there's a reluctance to adopt the guidance of the IP, or what is that dynamic like?
One of the points of discussion is how Sudanese doctors can better conduct medical examinations. And at the moment, they use quite a short form. It's just a single page. And we've heard from a lot of doctors that they would prefer not to use a longer form, but the problem is really just training, that they're not sure what to do. And from my layman's perspective, a longer form that has more detailed guidance would be useful. But I'm just curious, maybe this is for Juliet and Rachel, you know, how guided of an examination do you think is appropriate, or what kind of training is most useful for doctors who are really unfamiliar with these concepts?
Hi there, my name's Blanid Nicharney. I'm also a legal fellow at REDRESS, and this is not a planted question. But just picking up on a point that Stephanie made on the culture of disbelief that is quite sadly inbuilt within our asylum determination systems. I think a branch of that I've come across, that both within the legal profession and certainly within society, is that the misguided assumption that asylum seekers tend to buy the story that they wish to present. And I wonder, and this may be something for all of you, but Stephanie in particular, whether you foresee the protocol really being able to challenge or to dispel that assumption and attitude.
Right, thank you so much. So we have one question for you, Rachel, one question for Stephanie, and one open question. And just to note, as it happens, we were actually discussing that just before the start of the meeting, whether one should have a shortened version in place, what the pros and cons are of that. So I think that is has been a perennial issue, how to grapple with that, whether one would unduly compromise the standards then. So Juliet may want to talk to that, and David also has a few things to say, I'm sure. Right.
Thank you so much, and thank you for the question and the interest in the question of access to immigration detention centres, and also about the acceptance of the IP guidance. I think perhaps on the level of written policies, there are policies that promote or enforce access for independent doctors. In reality, of course, we're talking about part of a system that has a culture of disbelief. We'll move on to talk about that doesn't prioritise the welfare of the people in the detention centre. And so in practice, my experience and many of my colleagues' experience is that repeatedly we face barriers, disorganisation, chaos, inadequate facilities provided, people not properly informed, and a total lack of real care to ensure that independent assessments are promoted and facilitated, unfortunately.
Right, thank you, Rachel. Stephanie?
I think one of the really important things that medical evidence has done is actually to cut across the idea that credibility, personal credibility, is an end in itself, is at the heart of asylum determination. certainly that's how the Home Office treats it. But what has happened in the case law relating to medical evidence is that it has recognised, and we made reference to it a number of times, the case of KV Sri Lanka, which was the kind of epitome of a situation where the individual's account was said to be fabricated on the basis that they had inflicted deliberately, by a third party had deliberately inflicted scarring on their body that was entirely typical of being burnt with hot rods. So the court actually concluded at the upper tribunal level that it was an example of deliberate infliction of harm on yourself in order to claim asylum, which is at the most extreme end of this notion that that people might generate their own claim for asylum. And it was the fact that careful consideration of an Istanbul consistent approach to a medical report demonstrated that there was this correlation between the account of the particular infliction of these injuries and the medically significant symptoms. And on that basis, the court concluded that the judgment below was wrong. And in doing so, emphasised the fact that in an asylum context, you aren't determining the truth of the account in reality, because you're only applying a real possibility standard. That now has changed because we've got a higher standard that has to be applied since the new legislation, and it's going to be back to balance of probabilities. But still, that was an important point that the court made. And I think the 268 new paragraph is going to be important because it makes it clear and says explicitly that a doctor's role is to give an opinion on the veracity and reliability of the account that's been given. And so that's a really important statement that's new in the 22 version, although that's reflected in the current case law and recognition. So I think that will be important for being able to act as an argument and a buffer against this overwhelming idea that it all turns on the personal credibility of the individual.
All right, thank you.
I'll try and make a brief point on each of the questions raised. Access to detention facilities in the UK, I think the experience that Rachel and my colleagues share is particularly around immigration removal centres. Access has never been particularly easy. Whilst I can't say that there have been obstacles put in the way, it is certainly that there have been hoops that one has had to jump. I would take access one step further and talk about access to the clinical findings made by the doctors who themselves work in the detention centre, and those have always been notoriously difficult to get hold of. Now, that may actually change in the future because the Home Office are now insisting that medico-legal report writers who prepare reports on detainees must consider the findings of doctors in detention, and that, after all, is what the GMC guidance says. So for whatever motive it may be that the Home Office are improving matters on that front. As to reluctance to follow guidance of the Istanbul Protocol, I don't know how many of you are aware, but one of the detention service orders on the reporting of torture expressly mandates doctors in detention centres not to apply the Istanbul Protocol. And that is certainly something that we would all wish to be changed. On the other hand, the very, very short reports that are produced are then a starting point for medico-legal reports. And that can be established by the fact that they are not following the guidance of the Istanbul Protocol. And that then brings me on to the issue of the probative value of short-form reports. And it depends on the purpose for which those reports are being produced. If it is the intention of the state which is receiving the reports that torture survivors are properly identified so that all of their needs can be catered for, then yes, a short report may very well identify that individual. But if you are documenting that individual's torture or ill treatment, then one has to expect it to be to a certain standard. And I go back to Juliet's point, you must show your workings. And it's difficult to see how a short form limited to yes, no answers can perform that exercise. And finally, on the culture of disbelief and beyond, I was, until I think possibly today, surprised that paragraph 105F and 2875 had been removed, which more or less required the clinician to consider whether a false allegation of torture has been made. I'm now very pleased to be convinced, I think, by Juliet, that the reason that's been removed is because what we are looking at is a holistic process, and simply moving to a simplistic question and answer, yes or no, this is a false allegation of torture, does not properly perform that holistic process. And if we have a report which can say, as Juliet told me before we started, that the question which is now asked, which wasn't, I think, previously, is, do you consider this person is a victim of torture? Where the answer is no, there are methodologies which must be followed. But where the answer is yes, then assert that. Don't simply follow with a double negative. There is no evidence to suggest that a false allegation of torture has been made. And that is allowing doctors to positively assert their opinion. And let's see where that goes.
Juliet, any final thoughts?
Yeah.
You'll have the very last.
Okay. The fabrication issue is really, we took out those lines because we really felt that there was too much focus on this very specific statement. And as David said, and the questioner was raising this point, is this actually highlighting a prevalence of false allegations, which actually there is no evidence for that. And so we felt it was really important actually to take that out, to diffuse the concern, and as Ben said, to make a more holistic assessment, so you can still demonstrate that you are being objective and that you are weighing up what you find and not automatically believing everything. But the assumption that you've got to more or less prove it's not fabrication is taken away because there's simply no foundation for that.
Right. Thank you, Juliet. And thank you to all the speakers and to the panelists for such rich discussions. I really wish that we don't have to end yet, but I think this is very much an ongoing conversation. I said this is an occasion to celebrate the Istanbul Protocol, but of course we don't celebrate it as an end in itself. We celebrate it as a tool and a double-edged sword in some cases even, that one has to be mindful of it as a tool to bring about justice and accountability in various settings. And I think we've heard a lot about what the challenges are in the UK asylum and detention setting. So thank you again so much for contributing today. And I would like to actually thank you all in the audience and also for your rich contributions. And last but not least, I have some special thanks for people who have really made this event happen tonight. And some of you may have seen Camilla in the background with vital interventions, giving me signs. That is Camilla Mullen-Restrepo. She's been superb in organizing the event and really making it happen behind the scenes. So a very special thank you to you, Camilla. Would also like to thank all the helpers from REDRESS, making sure that everyone has a microphone in time or taking photos. That is Noel Wemsley, Rihan Jambi, and Juan Luis Gubbins. So I hope I have all your names. Those are the ones I could catch just before the event. If I have forgotten anyone, please forgive me. I would also like to thank the technicians here sitting in the dark room next to us who were really helpful and professional throughout, superb equipment. And obviously would also extend our really gratitude on behalf of all the organizers to Freshfields and especially to Debadas and Paul Yates, the partners at Freshfields, for providing us with this superb venue, and to Claudette Harris and Sam Evans for their smooth coordination and their support. So a lot of work has gone into organizing this event, and obviously it's a great pleasure to see that it has been such a fantastic launch of the Istanbul Protocol, and I think a call on all of us to do our utmost really to make it as effective as possible in the various contexts we work in. So thank you all. Thank you.